Hello, everybody. This is Advocate Lucinda, your empowerment lawyer. Today, I want to talk about disparate discrimination in employment discrimination cases. There are two: disparate treatment, which is considered intentional discrimination, and there is disparate impact, which is considered unintentional discrimination. And you need to be able to differentiate between the two. And we're going to hone in on disparate impact because discrimination is usually disguised and is more hidden than disparate treatment. So you need to be able to identify it. And that's what we're going to do. So let's get started. Disparate treatment, as I said, is intentional and it's more obvious than disparate impact. Let me give you a scenario. Let's say that company hires John, a male attorney, and Jane, a female attorney, as personal injury lawyers. Let's further say that Jane has 10 more years' experience over John, yet the firm pays John a higher salary. Let's further say the company hired a total of 10 personal injury attorneys, 5 males and 5 females. And let's further say not one female's salary is equal to or higher than any one of the male attorneys. After Jane discovered this, she wrote a letter to the firm's headquarters and complained of unfair treatment. And afterwards, the male managing attorney at the firm where she worked wrote her up, citing her action writing the headquarters was insubordination. Now, there is no policy, written or otherwise, that prohibited Jane from writing the letter. Also, the female associates were often disciplined when the male associates were not disciplined for similar conduct. Now, that's suspect, right? But let's go further. Jane sued the employer for discrimination, assuming she establishes the prima facie elements for disparate treatment. She has established disparate treatment at least to the extent she would survive a dispositive motion, such as a motion to dismiss. So, to remind you of the prima facie elements for a disparate treatment claim, to establish a prima facie element of disparate treatment under Title VII, now we're talking about Title VII, a plaintiff must show one, that he or she is a member of a protected class, two, that he or she was qualified for his or her position, three, that he or she experienced an adverse employment action, and four, similarly situated individuals outside of his or her protected class were treated more favorably. To establish an adverse disparate impact claim, the investigating agency must one, identify the specific policy or practice at issue, two, establish adversity or harm, three, establish significant disparity, and four, establish causation. So you see that policy is the central issue. It is so because disparate impact discrimination is often embedded in company policies and guidelines. Now, that does not mean that the discrimination is intentional. In fact, it's usually unintentional, as we'll see in the upcoming EEOC lawsuit. So let's look at the case EEOC versus Dogan Corp. LLC, doing business as Dollar General. It's a 2019 case. In this case, African Americans filed a complaint with EEOC in which they alleged Dollar General denied them employment based on their race, utilizing criminal background investigative results. EEOC found merit in the employee's complaint, and as a result, they entered an appearance on behalf of the employees and they attempted to settle the claim with Dollar General. But after Dollar General rejected the offer to settle the matter, EEOC sued on behalf of the employees. In the end, the facts demonstrated that between 2004 and 2019, Dollar General violated federal law by denying employment to African Americans at a significantly higher rate than white applicants for failing the company's broad criminal background check. And it also discovered that the policy screening had a disparate impact on the basis of race in violation of Title VII of the Civil Rights Act of 1964. After the discovery of this information, Dollar General and EEOC settled. In his statement regarding the settlement, EEOC Chicago District Director Julian Bowman added, because of the racial disparities in the American criminal justice system, use of criminal background checks often has a disparate impact on African Americans. This consent decree reminds employers that criminal background checks must have some demonstrable business necessity and connection to the job at issue. And it was also agreed between the parties and ordered by the court that if Dollar General chooses to use a criminal background check during the term of the decree, the retailer must hire a criminology consultant to develop a new criminal background check based on several factors, including the time since conviction, the number of offenses, the nature and gravity of the offense or offenses, and the risk of recidivism. Once the consultant provides a recommendation, the decree enjoins Dollar General from using any other criminal background check for its hiring process. So you see how discrimination here could be hidden and not clear to a party, although not intentional. It can be hidden nevertheless. I trust this has been helpful to you. And I'm Advocate Lucinda, and we will see you next time. Take care.